Jack Smith, very nervous about that March 4th trial date, and he's asking Judge Chutkan to hold the line. Don't move it. Even though he's appealing to the United States Supreme Court, even though Trump is appealing to the DC Circuit Court of Appeals, Jack Smith is asking Chutkan, let's keep this train on the tracks. We want trial on March 4th, the day before Super Tuesday, and so we're going to go through this very short filing just saying, hey, you don't have to change a thing, Judge. Keep this going. Then we're going to go right up one level to the Court of Appeals and see what he's telling them before we see what Mitt Romney has to say about Donald Trump and about all of this stuff happening. But first, this is Jack Smith. Now, motion to stay the January 6th proceedings was something that Donald Trump filed, saying, I want to stay the proceedings while this is all sorted out, as is his right. Jack Smith is responding to that, saying, I oppose Donald Trump's efforts. So this is out of the Circuit DC Court, out of Washington. 3 pages, very short. We'll take a look at the one that went right up to the Court of Appeals in a minute. Jack Smith's team, in this case, it's Molly. Highlight our girls here. Let's see what she says. She tells Judge Chutkan, hi, Your Honor, the court should deny Donald Trump's request for an order staying, quote, all district court proceedings while his interlocutory appeal is pending. Molly says, Trump incorrectly suggests that such an order would simply memorialize the automatic divestiture rule from Griggs. And Trump basically wrote preceding motion, the one preceding this. Chutkan, you have no choice. Thanks for playing the game. But once we filed this and appealed it, you're on notice that you're done. And so they're saying not quite. Under Griggs, a notice of appeal divests the district court only of control over those aspects of the case involved in the appeal. All right, so she's trying to split hairs on this, saying, well, some of those things I'm going to be appealing, that Trump is appealing, but other parts of the case, like you can keep working on. Like if you're upset with the garage, you can keep using the kitchen, right? It's just separate. And we're going to keep using the garage and just keep, the house is still functional. So they say during the pendency of the appeal, writes Molly, any number of matters could arise in this case that are not even involved in the appeal. And this court should not enter an order preventing it from handling them. And we're going, what kind of things? Like what kind of matters could arise? I don't know. It says, furthermore, the court should maintain the March 4th trial date. Okay. And she cites a case. And she said here, determining that it was appropriate as a matter of prudence during an interlocutory appeal to schedule a date with the court. So she just wants to keep it on the calendar. She says, so to help ensure that trial proceeds promptly if the court's order is affirmed, and during the pendency of Trump's appeal, the government will meet every pretrial deadline that we've already set. So she said, we're not moving a thing. We can stay right on track. Then, as soon as the mandate returns from the upper courts, the court can then promptly resolve any remaining issues and start trial. All right, so Molly is going to be like stretching, with the bands, all the things like ready to go in case that mandate comes down. Now, she says the rule applies automatically upon filing the notice of appeal, and so Trump doesn't need a separate order, and the stay order that Trump seeks is way too broad. Says the court should not assume at this juncture that no issue can arise. For example, she says the circuit court recently returned a mandate. Look at this. An order regarding extrajudicial statements. Okay. This is all about gagging Trump. Your Honor, in other words, don't put the DC case on pause, because if Trump says something that we don't like, we want to make sure that you maintain the court's jurisdiction over this case. Says likewise, nothing about Trump's appeal prevents the court for holding briefings and for issuing protective orders governing discovery, and also on conditions of release on Trump. So, Chutkan, you got to keep your gag jurisdiction over him, your protective order over discovery, your conditions of release, because a big part of being prosecuted in a criminal court is that you've got shackles on you, okay? Even if you're not in physical custody, you're shackled. You've got release conditions. You might have a pretrial services person you have to talk to. Trump's got gag orders, right? You're shackled to a calendar. You got to show up in court. You're shackled to your lawyer, right? You're in chains, man, from day one. And so they want to make sure that they can maintain those chains over Trump. And this is Molly writing accordingly. So in addition, she says, while the appeal is pending, the court can make headway on the motions already before it, including Trump's motion to dismiss based on statutory grounds and his other motion to dismiss based on selective and vindictive prosecution, which both great motions we're waiting to hear on. The court should promptly deny those motions under the rules, which provide that they have the authority to maintain jurisdiction over certain things. And she says, Molly tells Judge Chutkan, Your Honor, the public has a strong interest in a prompt trial, especially our friends at our cocktail parties. And the government will seek to ensure that the March trial proceeds as scheduled. In particular, the government will continue to meet all its deadlines, and this means that while the appeal is pending, Trump will not be subject to the burdens of litigation, and the government will continue to do our own work. And so we're going to keep working on the case. Even though Trump's not, the government will continue to give them everything, and we're going to continue to give them disclosure throughout the appellate process, and we're going to have all of our motions ready, and so they should have all of their motions ready too, so that if this comes back and is affirmed, this can be promptly litigated. And so please deny Trump's motions and decline to issue an order that they want. Signed by Molly Gaston, aka Highlighter Girl. Do not move the trial date. Even while they're appealing to the Supreme Court and the DC Circuit Court of Appeals, they want the trial to remain because it's basically all they've got. Now, this is the simultaneous appeal. This is the part 3 of Jack Smith's filings. He hit the DC Circuit Court with Chutkan, he hit the US Supreme Court, and now he's hitting the DC Court of Appeals as well. This one's an 8-pager. Says the government is filing the opposed motion for expedited appellate review. Now, this is another curious angle. In criminal law, we're talking about timing a lot. Timing about speedy trial rights. Does the defendant have a right to a speedy trial? Sure. So the government can't just throw him in prison for 100 years like they did with the Count of Monte Cristo. Same thing here, but a defendant also has a right to review his discovery and prepare his defense and have due process under the law, right? The government can't just yank a defendant through the process without any process. That's called due process. And so now Trump is opposing, in this case, the expedited appeal. So Trump has filed the appeal of presidential immunity and the double jeopardy arguments, but he doesn't want to go fast. Jack Smith wants to go fast. He wants to go expedited. Trump says no. So they're saying, okay, Trump is objecting to this, but Your Honors, here at the Court of Appeals, can we please go faster? And again, I go back to the question, why so fast, Jack? It's the election. For people who say that it's not about the election, it's about the election. Now, a grand jury charged, they say, Trump in a 4-count indictment, trial scheduled for March 4th. In a single ruling, Chutkan denied Trump twice. But in seeking a stay at the district court, Trump suggested that he intended to appeal their rulings on 2 issues, immunity and double jeopardy, saying that I was already acquitted during my impeachment and I can't be prosecuted again. But Jack says, come on, Court of Appeals. Come on, man. The public needs this case to go to trial timely, and the trial cannot proceed without a resolution here. And to further the imperative public interest in a timely trial, we seek a full and final resolution of Trump's claims, whether he's absolutely immune from federal prosecution while in office, or if the double jeopardy provisions apply. They say here that the government is filing all over the place, concurrently filing motions in this court. We also went to the Supreme Court, and we've also got an expedited motion with Chutkan. Now, when the Supreme Court acts on the government's petition, the government will promptly advise this court. So as soon as the SCOTUS people rule on it, we'll come let you know. And while the Supreme Court is considering the petition, however, this court has jurisdiction. Until SCOTUS says it's theirs, it's yours. An immediate entry of an expedited appeal in this court will ensure that this court can resolve Trump's claims with enough time for the Supreme Court to hear during its current term. So if SCOTUS says it's your ball, well, we need you to go quick. And if not, if they take it, we'll let you know about that so you don't have to work on it. So expediting this appeal will avoid the undue delay and is a common procedure. So they give us a bunch of law. Hey, we ask you to go fast all the time, so just go fast here as well. They say the same approach is appropriate here. And that's particularly true, especially because Trump is claiming he's immune from prosecution. Expedited proceedings like this are appropriate based on the stage here. And here, the government respectfully asks that this Court of Appeals expedite the briefing schedule and schedule oral arguments quickly. Why? The government requests that the court require that Trump's opening brief, so Trump's lawyers are like, we order them that they've got to respond to this no later than 10 days. The government is going to file our brief within 1 week of their brief, and any reply brief should be due 3 days after that. We have to go fast so that we can get him convicted before the election. Respectfully submitted, Jack Smith and his attorney, James Pierce, who is doing some appeal work, as you can see, counselor to the special counsel. So this goes up to the DC Circuit Court of Appeals, all certified, and we'll see who acts first, right? Who is going to be the first one through, and whether it is the Supreme Court or the Court of Appeals, we will be here obviously covering it. Here's Mitt Romney, who is out hitting the airwaves talking about what a maniac Trump is as we're watching this legal onslaught go against him. He is, I think, voting for Joe Biden or something. Here he is talking about how all this tyrannical behavior from the government is not really, I guess, tyrannical, and why Trump is the person we should really fear.
Do you think a second Trump term would look like?
Well, I think if you can look at the last few months of his presidency, you'd suggest that that's the kind of thing you might see. That he
Preserve
would
an
not
election,
have the generals
preserve a
around him
nation,
as he did last time, people of
Millie?
judgment and experience offering advice, and in some cases restraining his impulses. Instead, he would have people around him encouraging his impulses and perhaps adding to them. And I'm afraid you'd find the nation more divided. Look, our nation doesn't need to be divided right now. A campaign based on anger and hate may win at the ballot box temporarily, but it tears the country apart. The other day, the former president said that we are at greater threat for what is within. I think that was in some respects a self-own, because what's within, if he were to become elected president again, is a campaign of retribution and anger and hate. That's not what America's based.
Hey, that's what happens when you win. I mean, the Democrats went in and they prosecuted a bunch of Republicans. They went after all the J6ers. They're going after people who are alternate electors in various states now. What are you talking about, Mitt? It's not anger and retribution. It's governance. It's the new governance. That's just how governance works now.
America was based on the idea of in God we trust and united we stand, divided we fall. Divided nation is not the nation America is intended to be.
Oh gosh, is he running for president or something? What is he talking like that for? It sounds very Mitt Romney. All right, so that is what is happening out of the DC Circuit Court of Appeals. Jack Smith and the deranged thugs at his office are begging, whining, pleading to have the January 6th trial date scheduled for March 4th, the day before Super Tuesday. We'll see who acts first, whether the Court of Appeals will or Supreme Court. My friends, thank you for subscribing wherever it is you're watching this. Thank you for joining us at robertgovea.com. If you want to access any of these PDFs, you'll find them there, and we'll look forward to seeing you on the next one.